So before getting into the thoughts on transitional justice, I thought it was important to look at how the issue of transitional justice relates to justice in a transitional context. So what I mean by that is thinking about, on the one hand, you have transitional justice, classic interventions in the form of, be they truth commissions or prosecutions through international bodies or hybrid tribunals, what have you, whatever it may be, and then distinguishing that from justice in a transitional context, which I take to mean the justice system as it exists in transitional contexts such as South Sudan, and to think about how the two relate to one another. Much of my presentation will focus on analyzing the justice system in South Sudan. So in order to make it relevant, I think it's important to think about how that relates to the idea of broader discussion of transitional justice. And there are 2 points that I wanted to make there. First, the justice system as it exists is clearly a product of the conflict, a product of many decades of colonialism, of administrations by non-state groups, by Khartoum. In that sense, it reflects many of, if transitional justice is an attempt to deal with past human rights abuses as a way of reforming the state and making it more responsive to its citizens, how the justice system looks in the current context, I think is relevant to thinking about how to deal with those past abuses and is a manifestation of those past abuses, at least in some sense. So that's important. Then also in a very practical sense, one has to take stock of the justice system and what it can deliver and thinking about how to approach some sort of transitional justice intervention. So what is the existing capacity for investigation and prosecution? How are amnesties treated within domestic law? How do courts function? And it's important to take stock of that if one wants to, approach a truth commission or any sort of transitional justice intervention. In any case, that's my spiel for how it's linked, and that's the justification now, speaking about local justice systems. Coming to the demand for transitional justice in South Sudan, and I thought here there's again 2 broad categories that should be distinguished. I think everyone knows that Sudan went through a very lengthy conflict, decades of civil war, which I guess the primary protagonists were the government, Sudan Armed Forces, versus various rebel groups in the south, the biggest of which was Sudan People's Liberation Movement. And there was a lot of death, 2 million killed, 4 million displaced are the figures that get thrown around. Many of those through direct killing, others through famine, hunger, manipulation of food aid, etc. But then I think the other legacy aside from that north-south axis is the south-south violence, and where you had violence among armed groups in South Sudan, intercommunal violence, even within armed groups themselves, large amounts of violence. And I think that's sort of where the issue that's much more relevant than north-south violence, especially given the fact that South Sudan has seceded from Sudan and is no longer within the framework of the broader nation state that perpetrated these abuses during the war. The South-on-South violence, I think, is much more relevant. And then the second category of crimes is that of large-scale violence in the post-war period. So the civil war in Sudan came to an end in 2005, the signing of the Comprehensive Peace Agreement. Since that time, there's been large-scale violence that continued in parts of South Sudan. And that's, I think, another issue that is very relevant to the idea of transitional justice and needs to be taken into consideration in any discussion of transitional justice in a place like South Sudan. So looking at these 2 broad categories, for the former class of crimes, those perpetrated by Southern Sudanese against Southern Sudanese, broadly speaking, people are willing to forgive and forget, which is why in the Comprehensive Peace Agreement of 2005, we didn't see any mention of accountability for past crimes. No one really wanted it to be on the table, be it the brokers of the deal or the signatories to it. And even among South Sudanese, I don't think there's a big appetite for going back and dealing with these crimes in any sort of very tough way, at least at the current moment. It may change, but currently. Whereas for the second category of disputes, those which continue to plague the country, there you see a much more pronounced call for justice, for accountability, for trials, for rule of law to be applied to these acts. So again, one thing to think about in considering the demand for justice. To give some idea of this post-war violence, here's a timeline of recent attacks, large-scale violence in Jonglei State, which has been identified as one, if not the hotspot of violence in the post-war period. You can see hundreds of people killed, thousands, in months in a relatively short period of time. For the most part, there's been no accountability for any of these crimes. But yet, you see 300 people killed in April 2011, 430 June 2011, August 2011. The big attack was December 2011, where you had about 6,000 to 8,000 of one community called the Lo Nuer march on another community. Early reports said 3,000 people were killed. Some people think that was a gross overestimate. Others think that it was accurate. I don't know. And then more recently, in July, there was a similar attack of the Lo Nuer on the Merle. So to give some idea of the scale of this violence, looking at murder rates, from our assessment, we're able to generate sort of numbers, at least based on the perceptions of people at the household level. And the figures said 1,218 murders per 100,000 people, which is really off the charts. To give some comparison, the city with the highest murder rate in 2011 was San Pedro Sula in Honduras, which had 159 murders per 100,000 people, so you're talking about 7 or 8 times that of Honduras. This second study was done by the UN Office on Drugs and Crime and didn't include areas in the midst of war. So this was only countries that were not embroiled in war. And the two numbers use very different methodologies, and I don't think it's a little bit misleading to directly compare them in this way. But I just wanted to bring home the fact that there are really high levels of violence in parts of South Sudan at conflict levels that persist after the war. The typical responses to this violence are what I characterize as extreme versions of the carrot and the stick. So on the carrot side, we see peace conferences where everyone comes together, a lot of reconciliation, no justice in terms of be they prosecutions or other forms of criminal punishment. Coupled with blanket amnesties. So very often you see the government give blanket amnesties to entire groups of people. The amnesty will be open-ended. Sometimes it's renewed before you even know that it has lapsed. So a very broad approach to amnesties that we see. Coupled with the stick, which is forced disarmament campaigns, which have been continuing since 2005 on a pretty regular basis. In one of the early ones in Akobo, among the Lo Nuer, there were 1,600 people killed for 3,000 weapons reclaimed. So it's almost one person killed for every 2 weapons that were reclaimed in this early disarmament. So they're very coercive. And the most current one, which started actually while we were doing our assessment, was similarly thought to have very high death tolls with it. And then also counterinsurgency campaigns. So especially in Pibor County of Jonglei State, there's currently an armed rebel group led by a former theologian, and the government counterinsurgency campaign has been criticized for gross human rights violations and very heavy-handed tactics, to say the least. So here I wanted to draw your attention to this resolution. To address the conflict in Jonglei, the president put together a committee led by religious leaders to come up with a solution, and they held a conference, and this was the outcome of that conference, which identifies the problems as seen by the two communities involved and what they see as the solutions. Without going into too much detail about it, these are the problems that they've identified, and then their resolutions. And if you look at some of these crimes that are associated with the large-scale violence, so the killing of vulnerable people, abduction of women and children, and theft of livestock, you see, I think I go down a little bit further. In the recommendations, you see arrest and trial, enforcement of rule of law, trial of culprits. So the people were asking for arrest and trials, basically, and this isn't nothing new. It's been there even since during the war. This was a common theme, but until now, the justice system has been unable to deliver anything in terms of justice. Good. So now I'm going to move to try to paint a picture of what the justice system looks like in South Sudan. It has what's sometimes characterized as a plural legal system, meaning that there are these two distinct systems, one customary, informal, and one statutory, which coexist and provide people with sources of dispute resolution. The statutory courts are formal institutions presided over by trained legal people, judges. The cases take place in courthouses and structures. They very much represent the state, so they're seen very much as organs of the state. Decisions are based on statute for the most part. Sometimes the justice is characterized as adversarial in nature, meaning you have a winner and a loser. Whereas customary courts, on the other hand, are informal. Chiefs, traditional authorities preside over decisions. It's often held out in the open under trees, and people sort of sit around in circles. Non-state, meaning that their legitimacy is derived from the community, at least to a certain extent. They apply customary law, so this is what we mean by informal justice, the customs and traditions of all the various groups of South Sudan, of which there are 65 distinct ethnic groups. And the justice sometimes characterized as restorative in nature, meaning that it prioritizes outcomes that are mutually beneficial to both parties and that promote social cohesion, sometimes above a strict interpretation of individual rights. So this is sort of the theoretical distinctions. When you get to look closer, you see there are some ambiguities there. So we say that customary courts are non-state. At the same time, they're recognized in the Constitution, they're recognized in statute, they're embedded within the bureaucracies of local governments, sometimes paid salaries from the state. Yes, they apply customary law, but they can also apply statute, especially the penal code is applied very frequently in customary courts. And by the same token, statutory courts can apply custom, particularly the family disputes are almost always adjudicated according to custom in South Sudan. And restorative, yes, but sometimes much more adversarial, particularly with respect to theft, crimes which are considered to be very socially unacceptable. There you see a very sort of retributive inclination in customary courts. So in practice, things are not as clear as they would seem. And then even more sort of, I think, pronounced within a place like South Sudan is the role of other forms of dispute resolution. So people don't go to court as a first option. First, what they will do is go to family, friends, and neighbors, people within their close social networks, and try to mediate a solution. And there's a very strong culture of talking things out at that level in South Sudan. Also, church leaders play an important role in dispute resolution. People sometimes bring their disputes straight to the police, local government. So you have a very sort of complex web of different mechanisms at play. The distinction, the plural aspect of the legal system dates back to the colonial period with the idea of indirect rule, through which the British colonial empire made use of traditional authorities in order to administer justice. This was largely in the interest of expediency, because it's a lot cheaper to take advantage of the existing customary systems, and it allowed the British colonial authority to administer the region with very few people and at low cost. So that continued until 1956, end of colonialism, and the start of the first civil war. Sudan was then at war for the next 50 years intermittently, but still customary law was the primary means of dispute resolution throughout the conflict. And I think that really shows the durability and resilience of those systems in the midst of conflict. Then, as I said, in 2005, we have the Comprehensive Peace Agreement and the end of the Civil War. So the next question then is, what role does custom play within the new regionally autonomous government of Southern Sudan? At this point, it hadn't yet seceded. So this is a quote, I think, which sort of captures that point and what was facing the government of Southern Sudan at the time. In post-war South Sudan, customary law is being projected not only as a central element of the Southern identity for which the people fought, but as an important source of legislation, constitutionalism, and rule of law for the government of Southern Sudan. And this is the important part. There is, however, a gap between positive rhetoric and practical measures for making effective use of customary laws postulated. So I think there are two aspects to this quote that are important. One is that in 2005, when the government of Southern Sudan was created, customary law went from being simply something that was practical and efficient and expedient to now being a representation of the liberation ideals of the struggle. So it has an added significance post-2005 that at least wasn't there in terms of the formal state institutions prior to 2005. Then second, despite this lofty rhetoric, there's a gap, and people don't really know what to do in terms of moving ahead with building a nation based on customs and traditions. And I think that gap, I'll talk in a second about some ideas that have tried to fill that gap, but that gap is still a fundamental problem in all aspects of governance in South Sudan, whether we're talking about criminal justice in terms of how the statutory system and customary system interrelate and where the jurisdictions of the two systems lie, whether it's in land issues about what power does the government have over land which is administered by customary land tenure and which is outside the control, which is controlled by customary institutions. This is, I think, a very fundamental problem throughout all sectors in South Sudan. So here I just wanted to quote some different sources of law for how customary law, informal justice is recognized. It's recognized as a source of legislation. Traditional authorities are recognized as the transitional constitution of the Republic of South Sudan. Local Government Act also recognizes or sets up a system of customary courts. It restricts them from adjudicating criminal cases, at least according to the Local Government Act, unless they have what's called a customary interface, which isn't defined. But in practice, you see that customary courts deal with all kinds of cases, including some instances of homicide, and these restrictions are not adhered to. In terms of the strengths and weaknesses, I don't think I need to go into too much depth here, because I think I've touched on many of these already. The idea of restorative justice, I think, is something that resonates with South Sudanese and more generally with African perceptions of justice. Geographic and cultural accessibility, so where the formal courts, the statutory courts, are only present in a small fraction of the counties within South Sudan, mainly urban areas. Customary courts are everywhere, to the lowest, to the grassroots level. There are chiefs who hear cases. And then on this side, some of the weaknesses, also very important, I think, for any discussion of transitional justice is the inconsistencies with international human rights law, particularly with respect to women's and children's rights, has been identified as a source of concern. So in filling this gap between the positive rhetoric and practical measures to make effective use of customary law, at least three different approaches have come to the fore in recent years in South Sudan and maybe more broadly in Africa. The first is the statist approach, in which the government wants to take action to clarify the boundaries between the formal system and the informal system, very much wants to bring the customary system under state control in order to enforce standards and to regulate the system. In South Sudan, this has led to calls for the harmonization and codification of customary law, so meaning that a process of determining all the different customary laws that exist, harmonizing them to find a single customary law for South Sudan, codifying it into statute, and applying it in courts. It's been criticized heavily, but this is still the plan for many government institutions. A second approach I'll call the minimalist approach. This says that actually customary institutions do a relatively good job of responding to user demands and delivering justice in the terms that South Sudanese people want. The state should stay out of it to the extent possible. That in fact the government of South Sudan has such limited capacity and such a long list of problems confronting it that even if they wanted to, they wouldn't have the capacity to regulate customary courts. Then it also notes that the problems that are identified in the customary system are also there in the statutory system. Women don't do so well in statutory courts either. If you look at things like extended unlawful detention and the remand problems that are faced all throughout Africa, those are problems across the board and aren't distinguished between the formal system and the informal system. The last approach is one that emphasizes more of the human rights aspect, really highlights the dangers that customary law poses to vulnerable populations, whether it's permissive attitudes towards domestic violence, forced and early marriage, property rights, unlawful detention, some of these issues, and sort of calls for decisive action to bring them into accordance with human rights. So these are three sort of very distinct themes that have come across in the last, I guess, 8 years in South Sudan. So that brings me now to the assessment that South Sudan Law Society did in 2012 in 6 counties of South Sudan. These are the 6 counties listed here. They're mostly in the eastern part of the country, so this is the most mineral rich. It's where all the major oil fields are. Also the regions most affected by conflict during the war. The project had both programming and research components, so I was doing this assessment. Meanwhile, my colleagues were setting up legal aid clinics where they provided legal advice, mediation, also courtroom representation to people for different types of disputes. The goal was to establish a baseline, so we tried to cover as much as we can, and there was no, as a result, it's very general, but it at least provides some information which wasn't there before doing this. So the 6 counties that we looked at were here, these 2, Budi and Ikotos counties. This is Pibor County and Akobo, the 2 counties that have been embroiled in this very large-scale conflict recently. Rank County is up here on the border with Sudan. The Nile River, incidentally, goes up across the country like this through Rank. And Nasser County is here. So all 6 counties, first of all, are pastoralist regions. So all the communities in this area keep cattle and I think have lifestyles which are highly dependent on cattle, also heavily armed. Then also all 6 counties have international borders, and the cross-border dynamic was something that we were also looking at in its effect on justice. So I won't go into too much depth here. I think the important bit is that we captured both actual experiences, so what kinds of crimes did people experience, as well as their perceptions and opinions on justice. And the sample was 15-20 households. It was done together with National Bureau of Statistics in South Sudan. So this first chart is showing the question for each of these 10 types of disputes was, has someone in your household experienced this dispute in the past 2 years? So has someone in this household been killed in the past 2 years? Has someone in this household had something stolen from them in the past 2 years, etc.? And this shows the incidence rates for the 10 types of disputes that we highlighted. So the most prevalent was theft, at nearly 40% of households saying something had been stolen within the past 2 years. Next, we asked, after getting some information about the dispute, who was involved, that kind of thing, we asked whether the household member complained to anyone about that problem. And the interesting thing here, so the blue bar is saying, for those people who said yes, they did complain about something, excuse me, and the red bar is those who did not complain about anything. And what you see is that these class of crimes here, where the red is bigger than the blue, coincide with those crimes that are most associated with large-scale violence. So the homicides, the abductions, thefts, particularly of cattle. Here you see that people are far less likely to complain to anyone. And when you ask them why, the most common answer is that because there's no one to complain to. Because the statutory system is not present there. If it was present, it can't deal with large-scale violence on this scale. The customary system is present, but there's no mechanism for dealing with this type of violence within the customary system. So people are left without any recourse. If we go into more detail, this shows the rates of homicides. These are the numbers, percentage of households in each of these 6 counties that had 1 or more people killed in the past 2 years. The highest rate is in Akobo. Again, this is our county in Jonglei that had the large-scale violence along with Pibor. And very high rates of homicide, up to 27% of households, more than a quarter of households saying that someone had been killed. That include both accidental and intentional killings, incidentally. And then in terms of who was perpetrating it, for the most part, individuals from another village. This isn't conclusive evidence that it's inter-ethnic crime, but coupled with what we know about this violence, we know much of it is perpetrated between groups across administrative boundaries within local government. And I think this finding reflects that. With respect to the transboundary nature, also the role of the borders, many of these are gun-running borders and have been since the colonial days, particularly on the border with Ethiopia. and the ease of flow of weapons into the country is, I think, is one factor that contributes to the violence. Also, the ability of groups and individuals and groups to escape across these international borders, which are very soft. Particularly, you have cross-border, especially you take Akobo, and the Nuer population of Akobo is also in Ethiopia, and it's a cross-border population. It's very easy to move back and forth. So we had a lot of reports of people, even in isolated killings, who would kill someone and just run to Ethiopia and escape, as well as some of these armed groups that are responsible for the larger scale violence would use that border to escape. Another complicating factor is the role of historical grievances. So many of these go back to the war, atrocities that were committed during the war and people haven't forgiven, but they can also go back much further, land disputes during the colonial era, and sometimes you can have disputes that are 100 years old which are being dredged up again as justifications for violence. And then when the violence is committed, there's also a lot of hate speech that goes along with it, and language of exterminating populations, and very sort of gruesome violence. If one were to look at sort of the details of how these killings are done, it's a very brutal way with, at least on the surface, would seem like an intent to eradicate a people. Good. So now we're moving on to theft and abduction. So starting with theft, again we have high rates. Akobo stands out again, as it does in many of these crimes. Interesting, if we now the types of items stolen, 62% or 62.1% of the things that were stolen over the whole sample were cattle or other livestock. So it shows the role of cattle theft within these larger scale violence. And you can hear of tens of thousands of head of cattle sometimes being stolen, and very, it's acknowledged as, if not a driver, definitely something that's closely associated with large scale violence, the issue of cattle theft. Then abduction, which is also particularly pronounced in Jonglei State, these counties of Akobo and Pibor. 20%, almost 18.1% of households in Akobo saying they had one or more household members abducted in the course of large-scale intercommunal violence in the areas, and almost 10% in Pibor. And again, the perpetrators, we're seeing the inter-ethnic dimension by virtue of this figure here. Okay, so that sort of brings me to a close on that part. I think the goal of this, we published a report back in March which gives a lot more detail for anyone who's interested, but the goal is simply to try to better understand the dynamics of how this violence is working and how the justice system does or doesn't respond to the violence. And what we found for the most part is that for these categories of crimes, there are really little by way of options for people who have been affected by them. Okay, now I guess this is quite a pivot, moving to the issue of capital punishment, which I don't know how relevant it is, directly relevant to the issue of transitional justice, but thinking about how the criminal justice system works, at least in a place like South Sudan, and how do people perceive justice, I think it's an interesting issue. And it also gives perspective on a lot of different aspects of the justice system. Capital punishment was first introduced during the British colonial period, 1920s and 30s, when people were sentenced to death by public hanging for serious crimes such as murder. During the war, non-state groups also would administer judicial executions, now by public firing squads, which incidentally are still quite popular among many people, and they think it was a great way of controlling crime in South Sudan or during the war. When the government of Southern Sudan was created in 2005, at the end of the war, they continued administering judicial executions. Now it was hangings done in private as opposed to public, but they continued. And then more recently, there's been sort of a pushback and a call by, I guess, mainly human rights advocates calling for a moratorium to be put in place. So it started with the EU and the government of France, Comboni missionaries. This was on the top of long-standing calls from civil society in South Sudan for a moratorium on capital punishment. Then December 2012, the government of South Sudan voted for a General Assembly resolution calling on countries to put in place a moratorium with a view towards abolition. Since then, the government has said that was a mistake. They didn't mean it. They want to take it back. But in any case, it was, I think, an important moment, and it shows that the issue is gaining prominence within South Sudan. The arguments for the death penalty are pretty simple. Mostly deterrence and retribution, I think, are the main rationales that are used. Also, the idea that this is a new government and it wants to establish its power and sovereignty and the right to administer judicial executions, I think, is seen as the government showing that it's boss. Arguments against the death penalty, I think, are numerous, and even if I weren't a partial person in this debate, I would still think that the arguments against were overwhelmingly sort of convincing. I mean, one is, at least within the South Sudanese context, it's not in line with customary law. There's no capital punishment in customary law. Religious beliefs, most South Sudanese are Christian, and this goes against, I think, many faiths, at least Christian faiths. That lack of legal representation, so particularly for human rights advocates, the fact that 90-some-odd% of, probably 99.9% of people who are convicted to death, who are given a death sentence, had no legal representation and are convicted, without having opportunity to prepare a defense or call witnesses or anything. And then also this idea that life is cheap in South Sudan, and I think many post-conflict countries are like this, where the first reaction that people have is to go and react violently, and at least from I see this idea of capital punishment and being so willing to sentence people to death when you don't have a justice system that can establish their guilt, sort of just perpetuates the idea that life is cheap. I mean, yeah, okay, I won't go into more depth on that. So in terms of, how am I doing in time?
Pretty much.
Okay. Okay, let me move to these charts then. So we asked in our survey, one, do you support the death penalty? And we're anticipating widespread support. At least, most of the people we talked to were very supportive of it. And there's a very vocal segment of South Sudanese society that supports it. But at least in the 6 counties that we looked at, the majority of people did not support, or said they didn't support the death penalty, which I think was surprising for most people. And then under South Sudanese law, if someone is convicted of murder, the judge can sentence them to death. But if the judge does that, the victim's family is given a right to opt for blood compensation, or to accept a certain number of cattle from the family of the perpetrator instead of the death sentence. So this thing of blood compensation is actually a traditional remedy for homicide under customary law, where you don't have prisons. Under customary law, there's no death sentence. What they do is, if one person kills another, the family of the person who did the killing will compensate the family of the victim with a certain number of cattle. So this is sort of like, this provision under South Sudanese law is a melding of the formal and informal system, and allows the victim's family to opt for one another. So we asked people if they were given that choice, if a family member was killed and you're given the option to choose either to have this person executed or to accept compensation, which would you choose? And again, they overwhelmingly selected compensation. But now when you look at the county level, it gets to be a bit more interesting. And this is where I think one sees the impact of large-scale violence on people's perceptions of justice. In Akobo, I should say in Akobo is Nuer population, Pibor is mainly Malay population. And the Malay are characterized as the aggressors in all of this, across South Sudan. They're widely seen as criminals and people, it's a widespread stereotype applied to the Malay population. So of all the counties, the population in Akobo was the most in favor of the death penalty. And this is in line, I think, with their perception that they're on the receiving end of all this violence perpetrated by the Malay, and they think that these crimes need to be dealt with very harshly. Whereas in Pibor, overwhelmingly people were opposed to the death penalty. When I presented this information in South Sudan, my justification was that Malay people are distrustful of the state, So maybe they don't want death penalty to be applied. Also, they're a bit more isolated, rely more on customary law, and maybe the death penalty is not something that resonates with them. But then, of course, participants or people in these workshops that we did added another reason, which is that they're all guilty and they don't want to be sentenced to death. So in any case, there's some sharp distinctions at the county level. Okay, so I'll breeze through this. In terms of transitional justice initiatives, I think the major one is a Peace and Reconciliation Commission that was introduced by the former Vice President, Dr. Riek Machar, who himself has been accused of large human rights violations during the war, most notably the Boer massacre. And this became very highly politicized, and eventually the president stripped this initiative away from the vice president and put several religious leaders in charge. The vice president since was also removed from power by the president recently. In any case, that initiative is still going forward. It doesn't seem as though the type of thing that's going to have any strong justice element to it. It's much more seen as a sort of forgive and forget type thing, at least as far as it's been portrayed thus far. But in any case, that's the most high-profile initiative ongoing in South Sudan at the moment. And then also more recently, there's been a committee established on the prevention of genocide, which is in line with the International Convention on the Great Lakes region. So this is, I guess, been called the first intergovernmental body, the Great Lakes region countries, to operationalize genocide prevention, which is a new sort of issue that's been added to United Nations mandate. In South Sudan, most recently established an 18-member committee just last month, which is tasked with operationalizing genocide prevention in South Sudan, and it's the fifth of the 12 Great Lakes countries to do so. So there are some things that are happening in a piecemeal fashion, but nothing that shows really a concerted effort to tackle any of these issues yet. So I'll just conclude now with a few different issues, food for thought. One is the cultural diversity of South Sudan and the lack of a national identity, and how that affects efforts to try to develop narratives about past atrocities. As I said, South Sudan has some 65 ethnic groups. When it was part of Sudan, the identity was very much one of opposition to slavery, opposition to domination by northern Sudan, and that was thought to sort of hold people in South Sudan together and to form a common base for their identity. But since the secession of the southern part of the country, that is no longer there, and there's sort of a vacuum in terms of what is the national identity of the country. And if one were to try to now start talking about some of these past abuses, the differences among groups would definitely be something that one would have to manage. Also the lack of information. So I put some statistics up there. These are compiled by UN Office of Coordination of Humanitarian Affairs or something, but they're not thought to be very comprehensive. You know, these missions from the UN often go in several days or some cases weeks after the violence has already stopped. They're counting bodies, but they don't have access to the whole parts of the country. Other actors, similarly, access is limited, and it's very hard to establish the facts about really how many people are affected by violence. So I think a first step, even before thinking about what to do to address the violence, is to understand what we're dealing with in terms of scale and who's affected and that kind of thing. And also to think about using the justice system for prosecuting some of the people involved with these crimes. And that started in a sort of, in a very small way recently. There have been some arrests of military officers who are implicated in violence in Jonglei. Special courts are being used in different regions. So there's some small baby steps. One might call them, and I don't know how you would characterize them, but it's something that needs to be done in a more concerted way, and to think about what does the justice system need in order to hold people who wield political power, who wield military power. What does the justice system need in order to hold them accountable? And where do you put them? If you look at prisons in South Sudan, I'll show you some pictures at the end. That itself is a fundamental question. So the role of customary law, there are efforts underway to sort of curb customary courts from adjudicating more serious criminal cases. The danger is doing that when there's no formal system to take their place. So you really see gaps arising in places, particularly with respect to homicide, where customary courts are being told, do not negotiate blood compensation, is outside of your jurisdiction, but then there's no formal system to step in. And so when people don't have any other sort of justice option, they take the matters into their own hands and they go engage in revenge killings, and you have cycles of violence that then pick up from there. So I think that's a good sort of rule of thumb. And then lastly is to streamline justice into program initiatives across the board. So this would include all development partners of the government. For instance, if you're thinking of forced or say military campaigns to deploy judge advocates with significant military deployments, military justice people, which isn't being done now, to consider the use of more limited amnesties, so maybe time-bound or subject-bound. Amnesties for senior leadership could be applied for a certain period of time, after which they would lapse and they would be off the table. The broader sort of group would then maybe have a longer amnesty. Sort of thinking about how amnesties could be used more strategically, I think, is the question. And in a more justice, incorporate sort of more of a justice element. So those are just some final thoughts to end on. I want to show you some pictures. So here's the prison in Ikotos. This was the colonial prison, which is now dilapidated. It's in the mountains on the border with Kenya. So you see it's very rudimentary, and until recently men and women were housed in the same place. Typically you'll have about 20 people, between 10 and 20 people who have to stay there. Very little food. You had one time the whole prison population escaped because they weren't being given enough food. They actually have escaped numerous times from this prison. This is a prison in Akobo. I think this is a prison where you can only stay there if you want to stay there, looking at the door on that prison. People who are convicted of murder have to stay in this little cell here, and I think when I was there were 8 people who had to stay in that cell. Some people from Akobo. Good. I think that's it.
Thank you very much, David, and for the interest of time, I'm not going to do any wrap-up. It's a good, kind of like concentrated presentation. I was intrigued by a couple of things that I will throw out there, and then it is, you don't have to answer any of this, but there are things that thinking about them in the context of Sudan. Being from Darfur, and it was considered North Sudan, and now the South became a country looking at these issues like blood money, and not only that is ingrained in the culture of the entire country, but it has something to do with even the Islamic customary law, which is called the diya in Islam. If somebody kills somebody, the family, and it is not paid by the perpetrator himself. Actually, he or she does not pay a penny. It is paid by the family, by the clan, by the tribe, so that it shows that it can be a deterrent factor, and also you have a stake in controlling your people and your emotions, and because if one of them perpetrated this thing, you are going to pay for it. So it becomes a deterrent factor for the community, and that is, if that is becoming a way of doing away with capital punishment, I think it should be encouraged and should be taken further. The morale and the capital punishment, and the variations in the response of the people who some of them wanted and some of them in the two different communities, also was intriguing to me. It says a lot about the other side's trust of the state and the legal system. So that is maybe why they don't, we of course presume that they are innocent, and until proven guilty. And the final thing that I will comment on is the cultural diversity. We can see it clearly from here. One of the issues by which the contentious issues in Sudan before the separation of the South were issues of identity, and how the South at one time perceived itself has a different identity from the North, or vice versa. And these are issues that are complicated, and they need further investigation and research. However, I would say now that the South is separated from the North, we are finding that the same issues are in the South itself. And definitely the persistence of the problem in Darfur, added to it Nuba Mountains and the Blue Nile and so on and so forth, shows that these issues are going to be there, no matter what, and to look at this and to say maybe separation of the two countries in lieu of all the issues that you can look at, were not the solution, or somebody might say or claim that to the conflict between the North and the South. Other things remain equal. I mean, the passion of the Southerners to have their own country, all these things, we control for that. But if you look at this as an issue of identity, you will see that the North itself left with conflicting identities, the South separated, and it has its own conflicting identities. So dive right into it. The floor is yours, and we have about 30 minutes to get this place. Charlie, the Executive Director of the Carr Center for Human Rights Policy, joined us. He was supposed to be in this chair where I am now. So, sir,
thank you.
You can.
David, wonderful presentation. I was trying hard to see glimpses of hope in there, glimpses of a positive direction. And one of them I glimpsed was that in the crimes that were perpetrated, there were almost no government officials or police involved. It looked like they were minimally involved. I think if you would be in a place like Kenya or Zimbabwe, you'd say people had a very high rate of complaints about the police as criminals. Is this because it's a relatively new police force, or are they too busy dealing with the crimes of others to be engaged themselves? Or?
These are 6, well, not all of them, but most of these counties are among the most remote places in South Sudan. So police presence is extremely limited. Many of these, if the police exist within these counties, they're only within the center county headquarters, and there you'll have a few dozen, or maybe 100 tops. But as one goes outside of the county headquarters, there's absolutely no police. So I think much of that is attributed to a lack of presence. Also, I mean, clearly the police have been implicated in all these places, heavily implicated in abuses against people. I mean, we were having a public debate in Ikotos, one of the 6 counties, and I was sitting in on it, and they were talking about the issue of torture and how the police are always beating and torturing people for no reason. And this guy who was there representing the police stood up and held up a copy of, I don't know if it's a conduct manual or some law, and he cited a provision saying reasonable force. And he said, this means that we're allowed to torture you as long as we take you to the hospital afterwards, in terms of how they interpreted reasonable force. So I think, I mean, it's that I wouldn't take that as an indication that things are going well. Also, of course, the forced disarmament campaign in Pibor, there have been numerous reports, Human Rights Watch and Amnesty, and of very serious abuses in the context of that. In Pibor, incidentally, if I showed some of the charts that broke it down at the county level, you'd see a lot more government actors involved, whereas in other counties it seemed to be a bit less. So I think, I mean, generally speaking, there's a large degree of geographical variation in South Sudan when it comes to the characteristics of violence and how things play out. And in some places it is really just purely intercommunal violence. In other places it's much more the state playing a role. So yeah, I think there's...
Could be also a symptom of the weakness of the institutions themselves. And the police force was not actually developed in such a way that you can define as a police force in any other country.
Yeah.
And these are mostly officers who were in the SPLA, and that is the rebel group that finally became the army. And some of them were leaving the army and then becoming the president, and they are bringing with them some of the culture of dealing with, as a guerrilla group and being in an army, rather than dealing with civilians in a police force. Okay, please.
Thank you so much for your presentation. I have a couple of comments. I don't think either of them necessarily need an answer, but just sort of things that intrigued me from what you presented. And maybe I'll start with the data, given where Charlie went. I noticed in what you presented that the levels of complaint for a couple of crime types were actually quite high. So I think for spousal neglect came in at 75%, for adultery 70%, for rape 65%, something like that. Maybe it's, that's right, 63%. These seem really high levels of, I guess, a sensation that it's worthwhile telling someone, as though that some kind of redress is perceived to be possible. I'm not sure who they complain to, so perhaps that's another conversation to have. But it just seems unusual to me that people are finding it worthwhile to pursue some kind of redress for these crimes that in many other contexts that I've encountered are difficult for people to speak out about. The other piece that really struck me from your presentation was your sort of tripartite paradigm around the recognition of the informal system by the formal system. And I guess the reason it stood out for me is it resonates with some of the language that I hear government officials in Ethiopia using. So that one bucket of response might be keep them separate, stay out, both systems work perfectly fine. Another response might be something about sort of functional coherence and harmonization and codification. And a third response might be around substance, so finding areas, for example, human rights gaps, where the formal system might be able to acculturate the informal and exert some influence. So why do those three feature in the conversation in South Sudan? Why are they similar to Ethiopia? Are those paradigms that sort of a menu of options that most places can consider? And is there something specific about the conversation that you've heard in South Sudan that's precipitated that? And why is there that interest? Is there a concern in it, and who holds that concern? Mm-hmm. I'm sorry, they're polar opposites.
No, I think this excellent questions. I mean, for the first question, taking this, your spousal neglect and adultery. So for spousal neglect here, we're defining it. Let me try to remember the exact phrasing from my questionnaire. It was basically disputes among spouses that didn't necessarily involve violence. So typical complaints are, my husband isn't giving us money to provide for the family, or my wife isn't cooking for me, and this kind of thing, which really actually forms the bread and butter of customary courts. And this is really the most common type of dispute that arises. So I think these high levels for spousal neglect, also adultery. With adultery, of course, here we're talking about men bringing claims of married men whose wives have slept with someone other than, their husband, which is criminalized under South Sudan law. But, at least according to the letter of the law, any adultery, whether it's committed by a man or woman, is criminal. But in practice, you don't find women criminalizing or, complaining about their husband, at least complaining in a criminal sense about their husband committing adultery. In part because also it's a polygamous society, and adultery is how you get more wives, by sleeping with people other than your current wife. But anyway, in any case, those two types of cases are very much bread and butter of customary courts, and the accessibility of customary courts, I think, are reflecting themselves in this data that, they're accessible. With respect to rape, it was a very small sample size, and I'll have to admit that we sort of had to rush to get things going, and by the time we had our enumerators, we weren't able to get the gender parity that we wanted, so it was a lot of men enumerators who, and there's reason, if you look at the data, in some counties there were 0 reports of rape, so the numbers, it seemed as though there was serious underreporting in many cases. So that data, I think one has to sort of view in light of that. And it's widely acknowledged that women who commit rape are stigmatized by society, and as a result don't want to talk about it. Their families don't want to talk about it because a woman who's raped gets less in terms of bride wealth. So when she marries, a woman in South Sudan, if two people marry, the bride of the groom will pay cattle to the bride or to the family of the bride, and that will sort of be a payment that cements the marriage. They take the woman into their household. And for women who have been raped, that number tends to be lowered. Sometimes men will even rape women as a way of lowering bride price in order that they can marry them, because then the family sort of has their back against the wall and they have to consent to marriages. So,
Are abductions in that category? Because I know in Ethiopia, many young men will abduct a woman they want to marry to kind of force the issue with their family.
yeah, I think there may be some abductions that that fall into that category. I mean, the large-scale abductions that happen are mostly, at least in terms of how people blame them, they're blamed on the Malay population. There's a sort of, I don't know what you call it, a perception that the Malay have infertility problems, and this has resulted in historical events within that region. Some people don't buy it. Other people will say it's very much a fact, and that because of their fertility problems, they go and abduct women and children, sort of as a way of compensating. So there you find that very often abductions do lead to marriages, coercive marriages. Right. Sorry, I'm sort of losing track. And your second question was?
So I was noticing the three options
Right,
for
yeah.
the formal and the informal system to interact. I'd just love to hear a little bit more about how that conversation sounds and why those three options.
Yeah, if I were to give my own sort of take on how they materialized, the first option is the government of South Sudan, a couple senior people within the government who decide the best way forward is to draft a statute about it, and I think probably reflects a lack of capacity in the government and a lack of really appreciating how difficult some of these problems are, and that simply by making a statute, you look at experience in other African countries, and that really, when you try to codify customary law, you take out all the advantages of it, which is that it's a constantly negotiated process, it's flexible, it responds to people's demands, and you sort of render it, you reify it, or whatever you want to say, and it becomes much less effective than sort of living customary law. So I would say that initiative, the more statist approach, reflects sort of really an antiquated view of how to engage with custom, and something that has been tried for decades in other countries and proven unsuccessful. And maybe people just didn't fully appreciate the difficulty of doing that. At least would be my own personal take on that. With respect to the minimalist approach, I think this is a group of academics who are the real proponents of it, who have looked at time after time failed state interventions in South Sudan, even if you go back hundreds of years to the Ottoman Empire, to the colonial empire, to Sudan trying to administer South Sudan, and time after time, or even the current sort of development interventions, and people time and time again fail, maybe often in a well-meaning way, but still fail, and that I think that approach sort of takes note of that and says the best thing to do is sort of let systems, don't go in there and muck it all up. And then the human rights ones have been, I think, much more recently, where people have come very critical, and there have been a number of reports recently, very well researched and well produced, that really target the way the justice system imposes costs on people unfairly. Even targeting, in some cases, I would say it goes too far. I think everyone can agree that permissive attitudes towards domestic violence, for example, are something wrong. But then often people will take the next step and say that bride wealth system should be dismantled, and it's the root of the problem. And going into some of these institutions that are very much embedded throughout society, and one can't just go in and sort of eradicate bride wealth without fundamentally changing everything. And it wouldn't be possible to even do it at all. So I sort of think they're reactions to the context, the way that they arise, and they're not necessarily always so well considered. Personally, I think there's some truth in all of them, and one can learn a lot from all of them. But yeah, I don't know if that answers your question.
Well, David, really appreciate the presentation. I just have two questions that are kind of linked. On one level, I'd like to know how do persons on the ground see the parallels between the two systems, the informal and the formal? Is there a case where if there is a dissatisfaction with the outcome of the formal justice system, that the informal system comes into play? In Ethiopia, we've heard stories of persons who were sentenced through formal means, but once they've come out of the prisons, they're attacked by the victim's family, and is that something where it plays out in either way, where persons dissatisfied with the informal system say that, well, I will now try to route this through a more formal response? Well, that's the first question I have to.
Yeah, I think forum shopping is something that people have identified as very prevalent, and there's a report by the U.S. Institute of Peace recently, I think 2010, that was sort of very. I think take-home message of it is what's broke, don't, if it ain't broke, don't fix it, and looked at forum shopping as something that was positive and that people were able to essentially vote with their feet and choose which forums best suited their needs. So there's, I think, a degree of responsiveness across systems, informal and informal. In terms of, sorry, that's my mom's phone. Yeah, in terms of how people view the system, we have these distinctions between customary courts and statutory courts, but I think to a certain extent everyone just looks at it as the government, and sort of as the state. So it's not necessarily that people have a really sharp distinction that, one is customary, one is statutory. There's very little interrelation between the systems. So you have, you can have things which are adjudicated in customary courts. The loser will then go to a statutory court and bring up the same issue, or to another customary court, bring up the same issue. Similarly, you can go either way. You can have statute of limitations aren't applied. So we had a client who, I won't go through the whole story, but essentially she was fighting a child custody battle with the brother of her deceased husband. And it's dated back to, I think, 2004 was the first time we went to court, then again in 2011, 2013, and she just was constantly being dragged into court by this brother-in-law who wanted custody of the children. So it can work both ways, where people sort of do feel they have other options, but then also can be a way of harassing people. And then I think another important thing, particularly in counties such as these that are very remote and where they have less in terms of justice options, is self-help, and people very quickly resort. Their first, I think, reaction is to go and conduct a revenge killing. And in Akobo, we interviewed some of the people in the prison there, and there's, I think, 3 people who had all been imprisoned as a result of the same initial killing. So one person killed someone in another family, someone in that family came and killed this person, then the person in that family went back and killed someone in another family, and then all 3 perpetrators were in the same prison together. So you can have really these cycles of violence, and a large part of it is because there are no options, and people are affected by the war and sort of very quick to react violently. So.
Do you have a civil law system or common law system?
It's ostensibly a common law system, but in practice, there's no judicial opinions that are published. So since 2005, there hasn't been a single judicial opinion, which would be necessary in a common law system to know how other courts are deciding. So it's common law in name, but in practice, I don't know what one would call it. It's, you have a lot of judges sort of deciding. There's sort of rules which are applied. Very often statutes that are passed aren't explicitly referenced, so there's been a whole body of laws passed since 2005. Very little of it gets cited in court, and in some cases we put together arguments based on the Evidence Act that was passed in 2008 or Code of Civil Procedure from 2008, and judges just basically disregard legal arguments based on the statute and decide in accordance with whatever rationale that they want to apply.
Are they applying the same values that you might find in the customary courts?
For family disputes, definitely. There's a whole class of disputes. According to the Civil Procedure Code, it actually obliges them to apply customary law or Sharia for Muslim parties. to family disputes or inheritance issues, that kind of thing, are adjudicated according to customary law. It's often said actually that 90% of cases are decided in accordance with customary law, both civil and criminal in South Sudan. I don't know where that figure comes from, but it seems to ring true. But then there's a variation of the types of disputes. In Juba, you find a lot of land disputes, and for land disputes that involve registered property, that's strictly dealt with in statutory courts, and customary law doesn't really apply there. They're just, based on the documents that people bring. But yeah, I mean, one thing that's really lacking is a family law that would provide an alternative sort of form of dispute resolution for, upon divorce, how's property distributed, or for widows, what are their rights to property. But there is no such law at the moment, so everything is just done according to custom, which really, really disadvantages women.
I have two questions. One stems from one of your earlier slides. You mentioned peace and stability versus justice. I guess that's a common theme with transitional justice. And I was wondering, I also remember that you said, I think it was after 2005, people were in favor of just forgetting about it. Mm-hmm. And then after perhaps the more recent unrest, that they wanted some, I guess, justice or some accountability. And so I was wondering kind of what discussions were going on in South Sudan and what would be your prescription.
Yeah, I mean, I think what led to the CPA was sort of this no one thought it would happen. Even in the run-up to the CPA, all of the models, the Comprehensive Peace Agreement 2005, which ended the Civil War, no one thought it was going to work. Everyone was very skittish about it. It was a deal brokered by, I don't know, you probably could tell more, but about, I think, IGAD countries, some East African countries, also the Troika of the U.S., Norway, and Great Britain. And everyone it was like this very loosely cobbled together agreement. And the fact that it went through was a surprise to everyone. So no one wanted to really broach the topic of accountability. That being said, I think, the time factor is something that's very relevant, and, these things vary depending on people's time horizons. And, you had first the CPA was done a certain time, and then you had national elections in 2010 where there was a lot of problems. The independence referendum in 2011, where South Sudanese voted to secede from Sudan, which was also a tremendously uncertain time. And I think with this whole sort of series of one crisis after another, the issue of transitional justice has really been minimized. I think probably rightly so. But I think that's really what accounts for the lack of demand for accountability for these wartime grievances. But now, 2011, South Sudan is a new nation. That's not going to change. You have a new Peace and Reconciliation Commission, and I think you also have a lot of shakeups within the political landscape. If I were one who was interested in sort of having something happen, I would be biding my time and sort of planning and looking for an opportunity, and then knowing sort of how to proceed. The problem with the Peace and Reconciliation Commission, I think, is there's no plan in place. And the government, through the vice president, I think they're working with a Norwegian organization, or there's a Scandinavian organization of some kind. It's a very ill-conceived initiative, no real thinking about what they're trying to accomplish. And then going through the vice president in this highly politically charged atmosphere sort of doomed it to failure from the beginning. But, I think opportunities will arise as time goes on. In the immediate context, the issue of sort of justice for those crimes that are happening now and sort of within the more recent past is something that's very doable, and where people have been, both within the country and outside of the country, have been raising, more alarms. So.
That again a question to be contemplated in the case of Sudan as such, because Omar al-Bashir, the president of Sudan, is indicted by the ICC, and it was the first time that a sitting president was indicted. And so the question of peace versus justice came back. A lot of people are talking about it. But your question and the comments that are coming in and David's answer, altogether, if you look at them, put the challenge out there on, okay, if we talk about peace and we put justice in the back burner, and then looking at the situation in the country when there are issues of redress in certain crimes like this, or stopping violence, where would we start? Where is the priority? And so that is why some of the people who say no, Bashir should go to The Hague and should face justice and there would be accountability because of fear of this, because he was not taken to court, then we will see that the impact of that is the continuation of perpetration of such crimes like this, continuing in Darfur, in the Blue Nile, and later on in the Luba Mountain, reoccurring again, and it becomes a question of the chicken and the egg, how to address this. More lawyers like you guys are more kind of like more qualified to answer questions like this. But I'm just tagging a lot on this question. So
I was just picking up on what you said. I mean, so you don't feel that there is a sort of it would be something like the government wanting to impose some kind of general amnesty, like we've seen in Algeria after the civil war, for instance. You don't see this happening.
Meaning an amnesty for themselves, like the people who have...
Yeah, I'm saying, we just, they will know nothing will happen, we just forget about it and we'll just go on. Considering all the difficulties you've been depicting, for this.
It's not inconceivable to me that they would do that. There's a very casual use of amnesty. I think in part because of the weakness in the rule of law, and people don't really buy amnesty fully. It's more like just a tactic that's used as opposed to something that really carries a whole lot of weight. So you have people who can be granted amnesties and then they're taken off, and people are granted amnesties, and then in the process of them coming in, they end up dead, and you don't really know how that happened. And but it's not inconceivable to me that people would try to protect themselves. I think also with respect to this more recent violence, it probably reaches up a lot higher than these mid-level military officers who have been arrested. There's no conclusive evidence, and of course it's very hard to sort of substantiate these kinds of things, but I'd be surprised if it didn't sort of implicate senior figures within the government. Although I think currently they probably feel safe enough that to grant themselves an amnesty would probably expose them more than protect them, because of the weakness of the amnesty itself, and the fact that no one is really seriously talking about prosecuting senior political figures, at least for this. Corruption is another issue, but.
Last chances for Dr. Muhammad, unless we have somebody who wants to bundle a couple of questions.
Yeah, my question is very simple, because in Darfur we are seeing traditional cultural Judea system, which is a traditional system where if somebody was committed a crime, the part of the tribe take care of that, and the elderly will find out how can they solve the problem and mitigate the consequences of that problem. I'm asking how much this system is applied in South Sudan.
Yeah, it's very prevalent. I think typically it varies depending on the type of crime. If you're dealing with crime that involves the military, I think there the traditional system doesn't have the enforcement capacity. Like even if it wanted to adjudicate some of these crimes, it wouldn't be able to enforce any type of punishment on military personnel. But for killings that happen particularly within the community, typically chiefs will come and negotiate, mediate some type of compensation payment. Sometimes it involves cattle, other times it involves children. Sometimes they'll take a girl from one child and give it to the one family and give it to the other family. But if one is looking at large-scale intercommunal violence, so between communities, There, they do have conferences that they'll call, and the elders will come from each community, and they'll sit down and try to negotiate things in an ad hoc way. They're typically not very effective, and I think particularly when you're looking at large-scale violence between communities, I think the most prevalent response is fighting. For people to attack the other community as a way of preventing attacks against them, and if they can prove that attacks against them are costly enough, it's a way to deter violence. At least that's the rationale that's at play. And I don't think, except for maybe isolated incidents, I don't think the customary systems are able to manage this type of violence. And because everyone is armed, if we're talking about violence with spears as it was done 75, 80 years ago, okay, there the chiefs maybe have more power. Their perceived power to bless and curse also carried more weight at that time. But nowadays, with everyone using guns, it's not even clear who killed who. So if you want to negotiate compensation awards or traditional sort of healing ceremonies for murder, it's not even clear anymore how to go about that when you're talking about AKs and rocket-propelled grenades and that kind of thing. So I think there's been a breakdown at some level, but there's still a role for traditional authorities, and I think that's the million-dollar question is how do you approach it, and one would have to involve them in some way. But until now, there have been no workable solutions, I think.
Thank you so much, and to David Deng, who honored us with his presence today and gave us very good information and insight into the legal system in South Sudan and where transitional justice will fit into it. Thank you. Good night.